If we do not come to this court to seek redress for those actions, in our view, we cannot thereafter, after the pre-trial, come back and say, oh, but we've got one more point to raise. We wish to go to the pre-trial having done away with these issues.
But why? Do you say it is a legal prerequisite that you must finalize this issue before you can go into a pre-trial?
We feel it will be moot after the pre-trial, milady. It will be academic.
Why do you feel it will be moot?
An example of this, milady, should we sit down with the state at the pre-trial conference? First of all, we will be agreeing to the nature of the offence, that it's a Schedule 5 offence, that the particular charges within which it is brought. So we will say, for example, the money laundering charges were not extradition was not granted in relation of the money laundering charges, so we're only doing fraud and corruption. The minute we say that, that is us agreeing that indeed that is the process that we're moving forward with. However, in our application, we challenge that. We challenge the lawfulness of the prosecution. We challenge the lawfulness of the fact that the money laundering charges were not granted, and the fact that the extradition was based on the false misrepresentations that the state made renders that extradition process. They would not have granted even fraud or corruption charges if they knew the accuracy of the information.
Good.
And so,
but you keep on saying we feel.
Yes.
I don't see where the law requires of you to finalize this issue before the pre-trial.
Yes. I understand that, milady. However,
because, let me just say, because it often happens in pre-trial matters. Remember, a pre-trial in a criminal matter is not the same as a pre-trial in a civil matter. So it often happens in pre-trial inquiries that one of the parties would divulge to the court that we have an interlocutory issue to dispose of, and it is the following. So the fact that you will go to pre-trial in September does not prevent you from raising this issue.
Yes.
There's no law that prescribes that.
No, yes, we do agree with that, milady. We are not saying that if the pre-trial comes, then we are at a loss for what type of redress we will have. We're simply saying we decided to file now so that by the time the pre-trial comes, should we be unsuccessful herein, we will be able to say we had an urgent application, but we're still going to do X, Y, and Z. Instead of a situation where the pre-trial does come and then we raise these issues and then we wish to come to the court. And so there's no law in that regard, but we're simply saying in terms of substantive redress, September can only come with us having acted. Should we not act in this regard by September, April may come and the matter may not have been set down, may not have been finalized, and then we run the risk of either delaying proceedings, etc., milady.
But that will be speculation. You're now speculating.
Yes.
Well, so the first issue that I want us to clarify is that the fact that the pre-trial is set down for September does not prevent you from raising the issues at the pre-trial even.
It does not.
Good.
It does not. And that is not what we say.
The date of trial is only in April 2025, am I correct?
That is correct.
So what makes you fear the fact that you cannot place this matter on the normal roll, as we refer to it, and get redress in that way?
That is why we're saying, lady, we doubt that the matter will have been disposed of by April should we do that. However,
why do you say that?
I think perhaps it's practicing in Johannesburg for too long, but matters take quite long to get set down.
Yes, but you are now in the Free State division. Apologies for interrupting you.
No, that's okay, lady.
Because I do not want you to speculate.
Yes.
Our court rolls, you can have this matter on the roll within 3 to 4 weeks in the normal course.
Yes.
So if you say that you will not be able to obtain redress in the normal process,
yes,
then you are speculating.
All right.
So that cannot stand.
Right. So, but the point I think we were trying to make is that we opted to act as soon as possible after the facts became alive in the lower courts so that we could get the ball rolling and the process moving. As to the time frames within which we might get heard, I think that can be a matter of that happening during its time. However, the main point of the urgent is that we be seen to have come to the court as soon as it became alive to us that the facts that were revealed in the lower court and corroborated by the magistrate in her judgment are such that they require us to bring them to this court's attention. And so that's, I think, where we're going with this. We're not necessarily saying, should the pre-trial sit? We are out of options. Should the matter sit? We are out of options. We're merely setting out the timeline of the matter, and also that currently as things stand, she would be deemed as delaying the matter if this issue was still to be heard by the time April comes around. So we're not saying that if April comes around, there's absolutely nothing we can do. We're simply saying, based on when we learned this information, rather when the realization came and the state confirmed that indeed this was the case, we came to this court as soon as we could. If I may draw parallels with the recent judgment that we were referring to, one of the criticisms that the court leveled against that applicant was that she took a month to come to this court. And so we did not want to have to face that hurdle. We wished to show this court that immediately when we learned what we learned and the legal conclusions became apparent to us, that is when we came to this court.
Can you refer me to the case that you have now been referring to?
It appears first in our heads of argument, milady, at page 10 of our heads of argument. That's paragraph 23. Just under interest of justice, we have extrapolated the excerpts in that judgment where the court stated, first of all, she did not, strictly speaking, she did not comply with the requirements for the matter to be heard on an urgent basis, but that we were not seized here with an urgent application brought under normal circumstances. And that's, I think, also what we wish to highlight.
Page
10 of our heads of argument, lady. Paragraph 23. And the urgency in the interest of justice.
Page 10. And the case citation?
It's at footnote 17.
Yes.
Makudumana versus Director of Public Prosecutions. That's a 2023 case. ZAFS HC 223. And the paragraph we refer to in the judgment is paragraph 7. That's where Justice or Judge P. Lobsher made that determination.
And you refer to paragraph 7.
Paragraph 7, my lady, that's correct.
Now, paragraph 7 refers to the following. It states that, curiously enough, there was no mention in the notice of motion of relief sought on a constitutional basis. That was the issue there. Not the lateness, but the nature of the relief that was not sought.
Yes,
so
lady.
the relief sought was to declare the arrest and transportation to South Africa to be wrongful and unlawful.
Yes.
Only in a replying affidavit did the applicant aver that an extradition disguised as a deportation is inconsistent with the Constitution. So that's the issue in the paragraph,
yes.
Not the delayed possible delaying of the case.
Yes, but that's
but
not
the issue
reason.
itself.
But that's not the reason we rely on that dictum. The reason we rely on it is because the judge noted that there were shortcomings in the case as it related to urgency. And so there they say she did not provide anything in relation to substantial redress and how and when she could obtain such redress, and also she did not provide the court with a time period of what was she doing within that month that she could have come to this court. And the court then says, notwithstanding those shortcomings, it will be heard on the basis of the interest of justice. So what we're applying here is to say we are not blind to the shortcomings of relying on or using the pretrial as one of the instances that we feel we should come to this court on an urgent basis. However, that notwithstanding, we wish to point to the fact that this court has stated that even where they had such shortcomings, the court said, but on the interest of justice point, we will hear this matter. We say that we do not even have those shortcomings because we have a time period of about 10 days within which we came to this court and not a month. And also, I think, Milady, once we get to the interest of justice discussion, it will be clear why these are not issues that could be raised at criminal trial stage. By that time, the conduct of the applicant in submitting herself to that process will be such that it can be deemed that she recognizes the jurisdiction of the criminal court. That is all that we are saying, that we do not wish to present a situation where that can be inferred, and our conduct in bringing an urgent application wasn't.
Yes, but if you maybe you did not understand me. You rely on paragraph 7 of the case.
Unless
you
I might
refer me at paragraph
look
7,
at the paragraph that we're replying to.
In your heads of argument?
Yes.
Footnote 17, paragraph 7.
Yes.
Now, footnote 17, paragraph 7 of the case does not refer to the delay at all. It refers to the substance of the application. So maybe your reference to paragraph 7 of that case might just be in error.
Could I please
You're welcome. You're welcome to do that.
My apologies, Milady. That would be paragraphs 5 and 6. I think what we were quoting in paragraph 7 was the fact that it was not brought, this was not an ordinary urgent application under normal circumstances. Our apologies.
But paragraphs 5 and 6 still do not speak to your argument.
If I could please, Milady. Before the court follows such a course, it must be satisfied that the applicant has complied with the requirements set out in 612B. Namely, and I quote, the applicant must set forth explicitly the circumstances which is averred, render the matter urgent, and the reasons why the applicant claims that the applicant could not be afforded substantial redress at a hearing in due course. In the present application, it appears from the papers before me that the applicant has been in South Africa since 13 April and she was arrested in Tanzania. From 14 April 2023 onwards, she consulted with her legal representatives and has since appeared in the Magistrates Court where she has the right to apply for bail. This application was only launched on 19 May 2023. In her founding papers, she only relied on her alleged detention as the explicit circumstances which render the matter urgent. At the same time, she made no reasons She made no mention of any reasons why she could not be afforded substantial redress at a hearing in due course. Strictly speaking, she has therefore not complied with the requirements for the matter to be heard on an urgent basis. In addition, she has also failed to explain why she waited from 14 April 2023 until 19 May 2023 to launch her application on an urgent basis. I have little hesitation in finding that, under normal circumstances, courts of law would be loath to enroll and deal with such an application on an urgent basis. The court would rather opt to strike the application from the roll due to lack of urgency. However, I am of the view that we are not seized here with an urgent application brought under normal circumstances. And then the end of that paragraph says, therefore, despite the shortcomings in the applicant's application in respect of urgency, I regard it in the interest of justice to hear the application on an urgent basis, and it is accordingly enrolled as such. And so
that is now paragraphs?
That is paragraphs 5, 6, and then the beginning of paragraph 7, as well as the end of paragraph 7. This is the 5 June 2023 judgment. I think there's one in July as well.
Yes, yes. Good, thank you.
So that is the only way in which we're drawing parallels with that, milady. We're saying that this court recognized that the circumstances within which the facts of the matter took place were not facts of an ordinary nature. In this instance, we're dealing with an allegation by the applicant that, and also corroborated by the magistrate's order, that the state not only misrepresented but provided false information to U.S. authorities, and that false information was what they relied on to grant the extradition. And so the entirety of the facts of the matter are such that they are simply not of an exceptional nature. They not only do not take place within South African boundaries, they take place within an international law context, and also within the context of a large-scale corruption trial. And so that is why we're saying, notwithstanding our quips about the 11th of September and the pre-trial, we simply do not want to have a situation where the applicant is viewed as though she is delaying the proceedings, or that she's putting up certain arguments simply to put up arguments, but to point to the fact that this was the reason and this is why we are here, and if it should be set down on the normal course, we shall follow that process, but we needed to be before this court and not waste any time, as there was no reason to waste time. The facts are largely common cause between the parties. The facts were also corroborated in the judgment by the lower court, and so there was simply no reason for us to delay bringing the matter anymore.
Do I have the judgment?
It was transcribed this morning, lady.
Yes.
And
so it's rather awkward for me that you refer to the judgment and refer to it as the facts that are common cause, but I don't have it.
I was under the impression that it had been filed, my lady, our apologies, because it was supposed to have been filed with the heads of...
I have in the index... No, not in the index, except if it's loosely filed in the file, but I haven't seen it.
I do not think it would be, my lady. It was this morning, if I remember correctly, that they sent the email. We beg leave to hand it up if it is not any...
but it was not part of the index.
It was not, my lady.
It was indexed this morning, late this morning, but the transcribed record was not indexed.
I see, my lady.
Let me just find out from your colleagues if they are in possession of it before we proceed.
My lady, the judgment was handed to me at the commencement of these proceedings. I haven't yet had an opportunity to have a look at it, but I do have a copy of it in my possession.
Thank you. Thank you, ma'am. I also didn't have any opportunity to peruse it, so you stating facts as being common cause is rather perilous. Be very careful of that.
We weren't stating them as common cause with the judgment, common cause amongst the parties as they had been confirmed in the affidavits that had been filed. But then they were confirmed by the magistrate. So not common cause insofar as they're common cause with what the magistrate
in
has
the judgment.
Said. In the judgment.
So may I have a copy of the judgment?
As the court pleases. With regard to the state, milady,
Could you refer me to
Yes.
in the judgment a quo,
Yes, yes, my lady.
as to the issues that you have now raised?
Yes, my lady. The first would be contained on page 9.
Yes. Line.
Page 9. Apologies, that would be the... sorry, my apologies. The following page, line 9. Page 10, from line 6 to 9. The common cause fact there that is established is the fact that it was her failure to cooperate that led to the dissatisfaction of the investigating team.
You
and
are
that
now at line?
Line 5. Line 5 to line 9.
On page 10.
On page 10, my lady.
Then she at one stage cooperated, and after that she did not further cooperate. Is that correct?
That's correct, my lady.
Good.
So the common cause fact that is established there is that she was initially a witness and that she was only charged after the investigating team was dissatisfied. The learned magistrate uses the term that this was to the dissatisfaction of the investigating team, and a decision was taken to investigate further, and she was then charged. So that's the first fact. The second is on page 11,
Yes.
line 4 to line 10.
Yes.
Therein, the magistrate makes the first confirmed common cause fact in relation to why we are here, which is that she could not find any evidence that she had fled the United States or that she was a flight risk, because she was a resident in the United States and a student there at all times. And also she confirms that there is no evidence that it was difficult to get a hold of her when she was in need. That was the primary basis for the extradition request, that we have someone who is evading her trial and refuses to attend the trial, and we do not know her whereabouts. This was also contained in the affidavit that the state filed in the opposition for bail. But then lower there, the magistrate doubles down again, line 18 to 22. The applicant indicated that she was at all times still a student at the university attending classes. I do not have any evidence from the state that there was an instruction issued that she must inform the investigating officer of any change of residential address if she does that. That was the first fact. The second fact appears at page 13, lines 4 to 10. It appears from the replying affidavit that the applicant is not the cause of the delay of the trial, and it is supported by the arguments presented by the state as well. The delays were caused by a co-accused bringing different applications in the courts in South Africa, and this fits in with the version of the applicant that there was a long period in which she was not contacted regarding her being charged. One of the representations that was made to the United States was that the matter or the criminal matter cannot go ahead due to the fact that the applicant is evading trial and not attending the trial, and that is causing delays. And so the magistrate could not find any evidence of that fact herein. And then at the end of the same page 13, from line 20 to the end of the page, there was a lot of criticism from the state that the legal avenues that the applicant had pursued were done so in a bid to avoid extradition, appeal the extradition, and so forth. The magistrate here finds that there was no reason why she couldn't pursue all the legal avenues available to her, and her pursuit of those avenues was not indicative of the fact that she did not want to come back to South Africa or that she did not want to subject herself to the criminal process. But the most important one, and the reason why we're here, milady, is what appears at page 14, and that is from line 4 to line 9. The defense offered an explanation why they abandoned her bail application in the United States, indicating that there were false allegations made against her about her connections in other countries. This was not disputed by the state, although the state was given the opportunity to do so. That was a clear-cut allegation by the state in an affidavit, sworn affidavit deposed to, that the applicant had connections in Kenya. On this basis, the U.S. authorities decided not to release her on bail. Ordinarily, fugitives that are subject to the extradition proceedings are released on bail pending the conclusion of the extradition process. But in this instance, that is why she was there for 4 months in detention, owing to that one claim by the state, which was baseless and not based on any evidence or truth that she had connections in Kenya. The state, in fact, via the state advocate in the lower proceedings, then stated that he had actually made a mistake that was supposed to be Nigeria. But the US authorities obviously never heard that, nor were they told that this is only a suspicion. It was told to them as a matter of fact. And it is those representations that informed the seriousness of the extradition and how the US authorities conducted themselves in her extradition. It was that she's evading trial. It is that her whereabouts in the US are unknown. It is that she's a flight risk with connections in a country called Kenya. And for that reason, they cannot let her go. And she is evidently a fugitive from justice. And so we are saying, had the United States known that none of these facts were true, as Magistrate Delanga interrogated and came to find out, they would not have granted the extradition. Alternatively, if they had granted the extradition, they would not have granted the extradition in the manner that they did. And so that renders the extradition unlawful. These are not facts that we could come after the fact and come and state. This judgment is not a judgment that we can come after the fact and come and put up. Or rather, the initial impetus was that it has to be brought to the court's attention now, and that is why it is in the interest of justice, because we cannot have a state that is so free with making false allegations against innocent citizens that have such implications against them. And I do not mean innocent in the sense of the criminal trial. I mean innocent in the sense that she did not have connections in Kenya. There was no reason for her to be detained for 4 months in one of the most violent cities in the United States. There was no reason for any of that. So innocent in that regard, not innocent in regard of the criminal proceedings. And so if we move on with the case and we start preparing for the matter, and we're only bringing these issues into the fray now, not only are they irrelevant to that process, they're moot by that time, because by that time we have said, well, then we are submitting ourselves to the jurisdiction of the criminal court, but then coming to a court of law and saying the criminal court has no jurisdiction over her because the extradition was unlawful. And so that is the basis upon which we state that the interest of justice in this instance really do require that this matter be heard, be considered, and that any shortcomings in relation to urgency, we beg the court, we beg leave of the court that those shortcomings be viewed as it was by Judge P. Losha, to say, notwithstanding those shortcomings, the circumstances of the case are such that, and the implications are such that the interest of justice require that the matter be considered and determined. So on that basis, we have the urgency on interest of justice. Then it's the urgency on the basis that the state does not have any other ground other than to state that we could get substantial redress at a later stage. There's no other ground. They do not say these allegations are false. They do not state that the extradition was lawful. They do not state that the South African Criminal Court has jurisdiction. All they state in their papers, my lady, is that they can have substantial redress at a later stage. But as we've clearly explained to Milady, that actually cannot happen, because these facts arose out of something that we witnessed on the 14th of August, or rather between the proceedings of 12 August and 14 August. And so there is no time other than the present that these issues can be fleshed out and brought before the attention of this court. Because also, even though we were part of the extradition proceedings, up until the affidavit of the state was filed in opposition, those facts were not corroborated by the state. Those were only the applicant's allegations. And so even prior to that, we could not have come to the court because those would have been one-sided allegations. But after the bail hearing, after a magistrate has also looked at the affidavits and seen that there's incongruency between what the state claims and what has happened, and put that in her judgment, then we can come before this court and ask for substantial redress now.
Yes, but the fact remains, and that was my question, is why could you not get substantial redress in due course? Why did you have to come on such an urgent basis? Because even on, I think it's the 13th of September, when is the pre-trial?
11th of September.
11th of September. Even on the 11th of September, you can inform the court that you have this interlocutory issue that you want to address. Why do you say that you cannot do that?
Thank you, my lady. The main reason is due to the magnitude of the constitutional rights that have been infringed by the state's conduct. The fact that the applicant requires a court of law, the Constitution, to vindicate her in this instance. Indeed, perhaps in September, late September, these issues could be brought at that time. However, having spent 4 months in prison and then been in prison for about 7 or 8 days in South Africa when she got here, the magnitude of what the state's conduct has resulted on her constitutional rights require that we approach the court as a matter of urgency to say that quite apart from us wanting to abuse court processes or misuse court processes or the rules, the nature of the rights that have been violated and also the nature of the state's conduct is such that it requires the attention of the court. That's not to say that at a later stage it could not require that, but that was simply what was observed in terms of looking at past conduct where violations of constitutional rights have occurred. That has been the practice to almost run to the court for redress, and that is the reason why this has happened now. But also so that she can have certainty. If she is to subject herself to this process of sitting for the criminal trial, so that she can satisfy herself that she has exhausted all legal avenues available to her via the Constitution and can now subject herself to these criminal proceedings, not to muddy the waters and have her dealing with the same situation, drawn out trial after drawn out trial for this matter. That is and also because, my lady, as we stated, because of how many applications and affidavits have been exchanged between the parties, the facts are largely in common cause. One of the reasons why litigants might go in the ordinary course is because certain things need to be tested, certain evidences need to be put up. But in this instance, there is no denial by the state of these actions, nor is there any problem found with the findings of Magistrate Delanga. And so the facts as they are is how they've been accepted by the parties. And so it was also felt that we would not be presenting a disputed or matters that are largely in dispute between the parties before a court. It would simply be an interpretation of the law, an interpretation of the legal principles that apply in this instance. Not so much that we wished to, as I think the respondents called it, jump in front of the queue in front of other litigants. That was not the intention.
You mentioned a very, very important issue, and that is the dispute of facts. You say there is not a dispute of facts here.
Not on the material aspects, milady.
Not on the material
Not
aspects.
on the material aspects.
Not at all.
I can take milady through what we state are the material aspects, and where we state that has been confirmed by the respondents.
Good. I think for clarity's sake, just take me through those aspects.
The first, milady, pertains to what we deal with in our founding papers. That appears at page 26.
Yes.
Outlined from paragraphs 68 to paragraph 90 are the different state agencies that have explored the project that is at the center of the criminal matter. The reason that is outlined is these are state agencies that are legislated. These are state agencies that are constitutionally mandated to carry out their investigations, and these are state agencies that, were there reasonable or probable cause that the applicant was at all involved in this project, would have found something. Not everything, something. The reason why they're outlined there is to say that none of those agencies. The reason that is important is the timing that the state decided to find issue with the applicant, because that informs how they treated her in the US and how they have conducted this extradition proceeding. And so those are facts in common cause in the sense that the state does not deny the existence of those reports. What they do say to us is they wish for us to discover these documents, despite the fact that they had the Auditor General report, they dealt with it in the extradition report. They told the US, this is what we are basing this entire thing on. So we're not going to discover the Auditor General's report. And then the other reports are all publicly available documents that if you as the state are investigating the asbestos project ought to know about. And so we state that even when they try to find issuance, they discover these documents. They never stated that these documents do not exist. These reports were never conducted by these agencies. They simply, in the magistrate's court answering affidavit, stated they have no knowledge of the reports, which we state that cannot be true because they referred to it in another affidavit that they filed before the Constitutional Court and also in the extradition request, where they say that it was the Auditor General's report that first found that this project was irregularly procured and that all the investigations of a public protector of the SIU came out of that Auditor General's report. So that's the first one, because that speaks to the fact that it was only when she refused to cooperate that they charged her. That fact too is not denied by the state. They state that the only reason why they charged her was that they had evidence. And the facts are silent on when they got that evidence. They did not get them from these reports, investigation reports, because they did not find anything against her. It is only when she refused to implicate specific individuals that they did that. And so with that conduct, they do not deny that they told her that she was not cooperating. They do not deny the fact that she was initially told that she was going to be a state witness. They do not deny the fact that they told her to go and think about her answers and come back the next day. They state that that is not a threat. That was not a threat or them intimidating her or coercing her. In their affidavit filed in the lower court, they say it was not a threat, but it was a fair warning.
Good. But does all these facts that you've now mentioned come down to common cause? Because as you stated, it seems as if they do not deny, but they say they did not coerce.
That's
so
a matter of...
That doesn't boil down to common cause.
I would argue that it does, milady. It only differs as to interpretation of what that conduct means. And also that would be for the court to interpret whether that amounts to torture, mental torture, whether that amounts to coercion. But in terms of what was said and when it was said, those facts are common cause because that is not denied. I think that is what we're trying to
say. That's what you're saying. You're saying what was said in the bail application is common cause.
Indeed, milady.
Good.
And that is, it corroborates what they also said in the application they filed, or rather the affidavit they filed in the Constitutional Court. So the actions of the investigators are not denied. What is inferred or what can be inferred from them is denied. But that's a matter of interpretation. However, the actual actions, they do not deny that. That is what we say. And
good. That is a very important differentiation to make, that what was said is common cause, but what is in dispute, but there still remains a dispute. So it's not to say that the facts that you mentioned are common cause.
I think
They still dispute it.
They still dispute what the legal consequences of that could be. They still dispute what the legal interpretation of those could be. However, they do not dispute the material facts as they stand. The facts, not what can be inferred from the facts. They do not dispute that.
Some of the facts, yes.
Some of the facts, indeed.
Good.
The other issue is the Kenya averment. They do not dispute that this was contained in an affidavit that was deposed to by a state prosecutor, the state prosecutor that is involved in the matter. They do not deny or dispute the fact that that was what was sent to the USA and that the USA used that extradition request to inform its actions regarding the applicant. And so it's that we state that those are largely common cause, but it would be for the court to then look at it and say, well, from where we are standing, this was torture, that is unconstitutional, this was coercion, that is unconstitutional, but they do not deny at any stage what those facts were.
Good. I think my questions brought you a bit off track. Apologies for that. We were at urgency.
Yes.
And we went now directly into the merits. Yes. So let's return to your argument, and you can then organize your mind, and then you can proceed. Thank you.
Yes, Milady. I think when we branched off, I was still busy with the state's lack of opposition with regard to their grounds.
Thank you.
The argument there was that in order for a respondent to succeed in having a matter struck out for urgency, they would need to comprehensively show that this relief could not be obtained at a later stage or during the ordinary course.
Apologies, I must again interrupt you. On who is the onus in terms of Rule 612?
The onus is on the applicant to show in as much as possible that the facts support that contention. I think the point that we're making is that the requirement is that it's much more than simply stating they do not have urgency or that urgency does not favor them. More is required from the respondents to show in what way we do not deserve to be heard by this court on an urgent basis. And so our contention is that they have not shown that. They say that it is brought on an extremely urgent basis, and that is not correct. They do not state why that is not correct or why that is undesirable. And then they state it is based on extremely truncated time periods. But we have an answer for that too, to say in court we informed both the magistrate and the state that the facts that had arisen in that matter would be such that we could not deal with them in the lower court, and we would be approaching a higher court for redress. In their heads of argument, they do state that they do recall this. So again, that is also common cause that they heard us say that, and that from as early as 14 August, they could have been preparing what it is that they feel they did not prepare now in order for them to anticipate the case that we were talking about. It was not that we were going to come with new things. We stated there that it was going to be on the basis of charges, and it was going to be on the basis of the unlawful conduct, or rather what we felt was unlawful conduct that had come up in those proceedings. So to simply say that we don't have time and that you've brought this on an extremely truncated basis does not is incongruent, because from as early as 14 August, when we found out, we had informed them that we had this intention. And also, it is not extremely truncated. Extremely truncated would be bringing an urgent application the day after we found that out. We launched last week, after a week had passed from the time that we made that undertaking. And so then they bring the situation that the individuals that did hear this information, so that would be the investigating officer and the state prosecutor, went on leave and were unable to gather the facts. When we launched the application, or rather when the applicant launched the application, she could not have known that the state prosecutor was on leave or would be going on leave. Nor could she have known that the state prosecutor would go on leave. And so while those are perhaps valid reasons to a certain extent, they're not valid reasons in the sense that we knew that they were on leave and we launched nonetheless, which would have been a malicious urgent application. But also, the individual that is cited in these proceedings is the individual that is in charge of public prosecutions within the province of the Free State, who was not on leave. That's the Director of Public Prosecutions. At all times, when the extradition request was made, it was made by the Director of Public Prosecutions, which is why she is the main party, and all the documents to which we referred to were within that extradition request. Also, in the court application before the Constitutional Court, the Director of Public Prosecutions deposed to an affidavit therein and said she had read all the facts that had been stated on behalf of the state and that they were true and correct. And even here, with the opposed bail application, she had to have known that the matter over which she presides is before the lower court and that it was being adjudicated throughout that week. And so to come and say that she needed to have the state prosecutor present for her to understand how to respond to our case, and that she needed to have the investigating officer present, and that is why she could not respond on the merits, that is unlikely, we say, milady. And also, she is the head of the office. She's legislated to deal with prosecutions and to know what is happening with prosecutions. We could not have cited the state prosecutor in his personal capacity. He's not the head of office. And so the assertion by the respondents that this was extremely truncated, they could not come to this court with an answer to all of the allegations that we make because people were on leave, that is simply incongruent with the general practice of things and how directors of public prosecutions are required by legislation to preside over the matters they prosecute. We state that the reason she does not have anything to say in answer to us is because there is nothing to say in answer to us. The facts are clear. And what we deduce from those facts is clear. That if you lied to the United States, or as the magistrate more eloquently than I do puts it, if you presented false allegations to the state and they acted on that and an extradition was born out of that, that extradition is rendered unlawful. And in the case of the judgment by Judge P. Lopsha that we mentioned, he refers to about 3 or 4 cases in which the court states that where an extradition is unlawful, the court does not have criminal jurisdiction over that individual. And so that is also one of the reasons why we had to bring these facts in and the jurisdictional point, because then the precious judicial resources need not be squandered any further if, in fact, the matter can be resolved now and the extradition found to be unlawful and the criminal jurisdiction of the court found to be void or lacking. And so that is the basis upon which we say that's why she did not provide any allegations, not a single averment response to an averment. She simply just relied on the fact that we're not going to succeed on urgency, and she had confidence in that fact, and then also that if we were successful in urgency, this court would indulge them to go back and file or consult as they wish to and come together with the facts, and then us be heard at a sit. And that is not in keeping with what is required by Section 173 of the Constitution. It states that it is the court that has the power to regulate its own processes, not the director of the national director or the deputy director of public prosecutions. That simply cannot be, because even if they felt that we do not have a case, at the very least to respect this court's processes and file allegations in response to our meaningful responses to our facts. Because, as we said, milady, this did not present new facts. All of these facts have been canvassed over and over and over from the time that the extradition request was made in 2022 up until now. None of these facts are new. The only thing that was new to us was the misrepresentations that had been made to the U.S. government. And so, with due respect to the office of the director of public prosecutions, it simply just cannot stand that she did not provide a response to these papers, and the only worthwhile response that can be seen on the papers is a challenge on urgency, because as we've explained, on the interest of justice point, urgency actually is required, urgency is established, and a consideration at the very least of those aspects is possible, which is our. So on the basis of their case, they simply have not leveled up I cannot even say they have not leveled up a strong case. They have not leveled up any case, simply to say they do not have any urgency. But that is, again, the modus operandi that the state has consistently dealt with this applicant with, again, with the interest of justice. Time and time again, postponing or finding issues that need not be there. An example of this would have been the multiplicity of facts that were dealt with in the lower court that had no reason being in the lower court. Those were matters for argument in the higher court, but only so that she could be in jail longer and longer and longer until finally she had spent about 10 days in jail, whereas her co-accused had spent not a single hour in jail. And so that is why we're saying that these series of constitutional violations of this applicant have been such that really and truly they require a court's consideration and determination beyond just the bail application, but the actual merits of the case and the violations of constitutional rights that have taken place here. But having said that, milady, the point is well made and well received by us that this is not redress that we could not possibly, if pushed, obtain elsewhere. However, the magnitude of the situation is such that we simply had to present a court of law with these issues as soon as we could. So on that basis, milady, on urgency, those three pillars are what our case rests on. That substantial redress cannot be obtained, at the very least, the pretrial, but prior to the criminal matter, she would have to wait for the state to close its case. As the magistrate stated here, for her to raise that defense that the charges are unconstitutional, that the prosecution is unconstitutional, she would have to wait for the state to close its case.
No, I'm losing your argument there. Why will she have to wait for the state to close its case? Will that be in the main criminal trial?
Yes.
Is it your submission to the court that she cannot raise these issues that are before the court before the state has closed its case in the main trial?
That is our submission, milady. That is our submission.
Then I'm losing you. Then how can you bring it today?
No, that was not the submission, milady. Then.
So yes.
So
just choose your words carefully.
Okay, milady. In substantial redress, we dealt with 3 time periods in our heads.
Yes.
We dealt with, can she have substantial redress around the 11th of September, which would be the pre-trial.
Yes.
Then we dealt with, can she have substantial redress between the time period of the pre-trial and prior to the commencement of the case. And then we dealt with, can she, or is it possible for her to have substantial redress after the commencement of the criminal trial? And so our contention before this court was that no, because of the nature of the issues raised. The extradition has got no bearing on the criminal trial once the criminal trial has started.
Yes.
The extradition has no bearing on the pre-trial. At best, at pre-trial stage, she could claim that she has a valid constitutional challenge against the charges. But for her to be bringing the extradition issues at pre-trial stage would be, I think the word we used is incongruent, because what would be the basis of bringing that at pre-trial stage?
But why not?
I think, my lady, we have a different
I don't understand
understanding.
You brought this matter before court. I think I received the file. We received the file on Friday. The matter was set down now for Monday, 2 o'clock. The pre-trial is on the 11th of September. You received the judgment on the bail application on
14th August.
14th of August.
15th August.
15th of August. 15 August. Good. 15 August, about 10 days later, you filed this urgent application. Because you say you cannot obtain redress in the normal process under the uniform rules of court in terms of Rule 6. You could not obtain that. That is why you are before the court today. You say so because the pre-trial hearing is set for the 11th of September. So my question to you is, why could you not have set this matter down on the normal roll in terms of Rule 6?
That would require, for us to start the matter from scratch, milady. We'd have to file the finding, wait for the state to file its answer, file the reply, file the heads, wait for the state to file their heads, and have the matter sat down. Before the 11th of September, we were not confident that we would have a hearing by that date.
Good. But you could have started the process on the 15th of August.
I think the decision was that we rather start this process,
Yes.
lady.
Good. So that the first point, the 11th of September. You can still inform the court, the presiding officer, at the pre-trial hearing, that we are busy with an interlocutory application where we challenge these issues, and we would want a remand to address these issues. Why can't you do that?
It's that last sentence, Melissa, that requirement or request for a remand. There is no confidence on the part of the applicant that the state would be forthcoming, or rather would be cooperative with her in getting that remand, but rather that her actions would be viewed as an attempt to delay.
Good. And then from the 11th of September until April next year, why do you say that you cannot obtain redress in the normal course then?
For largely the same reasons, milady. Because when she, I'll go back to, I'm making an example by going back to something. When the magistrate's court certifies an extradition and says this person is extraditable, the Secretary of State is required to look at whether all the procedural elements were present. And then he invites the fugitive to submit submissions if there's any further information that they feel the Secretary of State is required to know. Those submissions were filed by her legal representatives. So the South African legal representatives and the US legal representatives working together, we filed those submissions just to motivate that. She's a student, she's never been convicted of an offense, she's going on the final year of her degree. When that issue came to South Africa, the state mischaracterized those submissions as an appeal to avoid extradition. And so the applicant is aware of the manner in which the state deals with her. And there was no confidence on her part that if they had done it with mischaracterizing her filing of innocent submissions as yet another attempt to evade extradition, that they will not do the same in this instance as well. And so that is why it could be deemed as yet another delay tactic. There was already a portion of the heads or the answering affidavit in which the state states to this court that she stated that she was going to sit for her trial and that she would see the trial through. And so now she's bringing an urgent application. Already there's a mischaracterization of why the urgent application is being brought. That, she never had any intention of sitting for the criminal trial in the first place. She just wanted to get out on bail. And now she's using every single legal avenue to try and get. And so there's been constant mischaracterizations of this applicant's behavior where there was no reason to. And so I think Milady is proceeding from the premise that the state is a fair, objective, reasonable entity when it comes to this applicant, but that simply has not been her experience, and that is why she feels should she follow the normal processes, it will be mischaracterized as yet another ploy to delay the proceedings or to avoid sitting for the criminal trial. Over and above the fact that the feeling on her part is that the sooner that a court of law can determine these issues and see these violations of constitutional rights for what they are, the better. But over and above that, just from the manner in which they've been dealing with her in this criminal matter, there's no confidence on her part that that would be bona fide and that would be interpreted in the way that perhaps it ought to be if it's interpreted generously.
And that is why she brought the application on an urgent basis.
That is part of why, indeed, Milady. But the larger considerations are the interests of justice considerations on her part.
Good. If we go to the interest of justice and public interest of justice, public interest, it's a very important issue. And when a court should adjudicate on public interest, is it not imperative for the court to have all the facts?
That is correct, milady. I think that's why we were so meticulous in providing all those facts in our founding affidavit and filing a 30-page affidavit. It's also why, to a large extent, there was disappointment with the response, because at the very least, I think we expected an equally meaningful response, so that even if the applicant were to not succeed on urgency, she understands that the state has a case against her allegations. In the current instance, if she were not to succeed, she was going to have to go forward with a legal process with a state that has not been coming to the party in terms of providing meaningful responses thereto. And so we tried as much as possible in formulating, painstakingly formulating the founding affidavit in such a way as to provide every single material aspect that is relevant to the present proceedings. But Milady would be correct in the sense that the court would require, or rather, it would be advantageous for the court to have time to really ponder upon the issues. And in that instance, as I think I keep saying, my lady, that the main important thing for the applicant was to bring the matter. As to how long perhaps it would take for the court to deliver a judgment, for example, or deliver reasons, that is a different story. But it was more important for her that she instruct us to come to the court as reasonably early as possible. But to the point on public interest, in the instance, and it might be speculation, but I submit it is not, milady. However, one of the issues that also would be problematic if she had brought this at a later stage, let's say after her pre-trial, it would not be understood in the light that it should be. It would be understood that she's only doing that to avoid criminal trial, avoid sitting for the pre-trial, and not for what we submit. It is understood now that her main thing is to vindicate her constitutional rights as she observed them to be violated, and this was the time that she decided to bring. And so it's not to vindicate with the view to delay or to vindicate with the view to avoid, simply to vindicate, which is why we keep repeating that once this is over and the merits or the portion of the declarator has not succeeded, she will then submit herself to that process freely, and also focusing with her legal representatives on one issue and that issue alone. But for the time being, it would have to be multiple issues at once, which she would have to then also bear the costs of. So that is why this window, we say, is the window within which we could approach this court and obtain substantial redress.
Good. Now, this is an application. An application is adjudicated on the Plascon-Evans rule. What must I do with that? We've got your version in your affidavit. We've got the version of the respondents that say, we are not ready. We're not ready to put all the facts on the table. The timelines have been too truncated. Our people are not available to do the statements. That is in their reply. And you came and you replied again. But what does the Plascon-Evans rule say? What must the court do? Whose evidence must the court accept?
Yes. Milady, the Plascon-Evans rule requires that where an applicant has brought a respondent to court, because the respondent is automatically on the back foot in the sense that they cannot reply to the reply of the applicant, the court must take into account the respondent's version together with the corroborated or confirmed facts that the applicant has brought.
Common cause.
However, the exception there, and that is what we rely on, is that only insofar as the respondent's version is not that far-fetched or untenable. And we state that as things stand, their response and their reply and their version is too far-fetched and untenable. It is untenable that a director of public prosecutions would not have a response, even if it was a 10-page response, other than on urgency, just on the material facts that have been alleged. It is untenable that she would not have that, bearing into mind how much facts actually are within her knowledge, which was confirmed by the extradition request affidavit and the Constitutional Court affidavit. And then it's also far-fetched, because even if the state prosecutor was on leave, and even if the investigating officer was on leave, the investigating officer deposed to a confirmatory affidavit. If he could depose to a 7-page confirmatory affidavit, he could depose to a 7-page affidavit on the facts. If he could consult with his lawyers on a confirmatory affidavit, sign it and scan it over, he could do the same thing with regard to a response. It is far-fetched in the sense that it just simply cannot stand that the only reason there is no version of the state before this court is because of these extenuating factors. Our version, or rather our contention, is that in fact the state simply does not want to place a version on record before this court in relation to their actions on this extradition. They wish to avoid that at all costs, which is why they go with a far-fetched approach as well of claiming not to have documents of other state agencies. This is the National Prosecuting Authority. It's a Chapter 9 institution, just as the Auditor General is a Chapter 9 institution, just as the Public Protector is a Chapter 9 institution. If the Public Protector claimed to not have a report of the National Prosecuting Authority, we would not accept that as a true fact. They have it. They've seen it. They know what it is, particularly if they're also investigating the same thing. And so the state knows that she was not implicated in any of these reports. But then they put the version forward that no, they have no knowledge of these reports, and also ask us, since you referred to these reports, can you make them available for discovery? That is far-fetched and that is untenable. And so Plascon-Evans would apply here, as we stated, if this state, or rather these respondents, had put a credible version, no matter how short it would have been, a credible version before this court to say, even if there was a false allegation that was made in relation to the extradition, it's immaterial because the charges against her are so serious. Even if she spent 4 months in prison, that was not on the basis of our actions, that was on the basis of the U.S. authorities. Even if the opposition of her bail, we leveled an opposition and we did not with the co-accused, it was because we believed her to be a flight risk. Whatever the case may be, a version, a credible version on the facts that they knew. And so for the Director of Public Prosecutions to come in and say, I cannot put a version forward because people are on leave, is simply far-fetched. It is simply untenable. And that is why that proviso is there in Plascon-Evans to say, ordinarily you would take the respondent's version, but we have not placing a version before this court, then or bringing one that is so far-fetched and untenable that you have no choice but to take the applicant's version. And so I think that's what we would respond to that, milady, just to say it would be a different argument altogether if we had some type of meaningful version on the papers, and we do not think that that meaningful version can be attained through further prolonging of the situation. We simply submit that no such meaningful version exists because the evidence of their actions is clear, and it is on black and white, and the magistrate could see it, and nobody laid evidence in cross-examination. It was clear to the magistrate, just on the basis of the affidavits that were placed before her and the state's version, which also corroborated, or where they could not dispute certain facts. And so that would be our response to that. Long-winded, but that would be our response. No,
not long-winded at all. Thank you. Very, very informative. Thank you, Ms. Makapela. Thank you. You done?
With the urgency.
Yes, thank you.
Thank you, Mary.
Thank you, Ms. Please, you may proceed
As
on
the
the
court
urgency.
pleases. Lady, it appears that this application has been brought on this extremely urgent basis in an attempt to embarrass the state, and from some of the submissions my learned friend made today, many of which are not on the papers, it seems that has just corroborated that view. This matter does not deserve the attention of this urgent court. It has been brought extremely urgently for essentially declaratory relief, and this is not relief that is sought in respect of current rights, current abuses or alleged abuses of constitutional rights. This is all for historic abuses of constitutional rights which are alleged. And if I can just make it plain at the outset, although the state has not, and by the state here I mean the state actors that have been cited as respondents in this matter, although they have not dealt with the merits in this particular application at this point in time, they did indicate in the answering affidavit that it will be opposed. The court has already seen from an annexure to the founding affidavit that when a previous application, very similar to this one, was also brought in the Constitutional Court on an urgent basis and by way of direct access, some of the same respondents here did oppose that application, and that affidavit was attached. So the court will have had cognizance of that and seen that there is a defence. For the record, the Constitutional Court did not hear that application and felt that it was the requirements for direct access were not met, and neither was urgency. And yet here we are, that was the 26th of July, we're here exactly a month later, and we have another urgent application. So I submit that if there's any abuse that's taken place in this matter to date, it's on the part of the applicant and certainly not on the part of these respondents in this matter. I point out that the applicant is currently out on bail. Her bail conditions are lenient, and as far as I'm aware, she has not applied for any change in circumstances as to her bail conditions. There is thus no liberty that's at stake in this matter. As my learned friend in the courts now know, there is a pre-trial hearing which will be taking place on the 11th of September. This application could have been pursued in the ordinary course, brought to the attention of that presiding judge, and then dates arranged for the hearing of that matter well in advance of the trial, which is still 8 months ahead. The prejudice that the applicant has alleged, and a lot of it unfortunately came from the heads of argument that have been filed, which were just handed to me before this matter started, and from my learned colleagues' address to the court, is simply not on the papers, is not borne out in the papers. The only grounds submitted for urgency were the interests of justice, which were left broad, and also the fact of the pre-trial on the 11th of September. I submit that that certainly doesn't comply with the established case law, that in order to move an application urgently, one needs to show that substantial redress cannot be obtained in due course. And as my learned friend in the court had that discussion earlier, that onus is on the applicant.
And of course prejudice. Prejudice comes into play, and where lies the prejudice? If we look at both sides, if we look at this, well, we can loosely refer to the state. I don't know who the state is. The state, I suppose, at this moment is the Director of Public Prosecutions, the Minister of Police, and Captain Benjamin Friedemann Carlitz.
Yes.
If we loosely refer to them as the state, the three respondents, wherein lies the prejudice for the state should the court hear this application today?
For the state, my lady, the prejudice is extreme. We have set out in the circumstances of this matter where the individual, all three respondents, were not in a position to oppose this matter properly today. But there's also the further prejudice proceeding on this matter that the court will have been made aware that previous co-accused of the applicant in this matter have brought similar applications some time ago, and there's been judgment of this court confirmed further by the Supreme Court of Appeal and the Constitutional Court, and that this type of litigation should only be dealt with at the commencement of the criminal trial. It is that court that is best placed to deal with these sorts of arguments because it has all the facts and evidence in front of them. And interestingly, on that point, the case that my learned friend referred to in the application, in the founding affidavit of S versus Mahala, a similar point seemed to have been taken there, that the accused was brought from the then Republic of Sisca into this country unlawfully, and a challenge was made to the court's jurisdiction there. What that accused did, though, and we submit that that is the correct procedure, is that accused raised it as a special plea when pleading at the criminal trial that the court did not have jurisdiction. Then there can be a hearing on viva voce evidence or properly prepared on papers where everyone has had ample opportunity to prepare their cases as to whether the criminal court has jurisdiction over the applicant. That can be done on the 15th of April 2025. So the state has been prejudiced by these sorts of points being taken now before there's been any plea. My lady, if I may then hand up, these are not new matters, they have been referred to in my heads of argument, but they're the unreported decisions which I just beg leave to hand up to the court, and I'd like to just take the court through certain points.
Give copies to your
I've handed them to my lady.
Colleague, thank you. Just for record purposes, I marked the record of the court below as Exhibit A. Thank you. You may proceed.
As as the court pleases. My lady, the first unreported decision is referred to in my heads of arguments, and I apologize, I do not have an index of the pages, so I've only got the page numbers on the documents themselves. It's the Volvo decision. It's Volvo Financial Services Southern Africa Pty Limited versus Adamas Tokolosi Trading CC. It's a decision of the Johannesburg High Court, and it is referred to in the heads of argument. Just bear with me. It's at footnote 6 and paragraph 7 of the heads. My lady, in this case just confirms that there are no matters which are inherently urgent. The court does mention spoliation there, but because we're dealing with constitutional rights here and allegations of breaches thereof, I submit that that does not automatically render this matter urgent. It may have been a different story if, as this judgment points out, there was a threat to life or liberty or housing, water, things of that nature, where there's a threat ongoing in the nature of an interim interdict or something like that. But that there have been alleged constitutional breaches in the past certainly does not render this matter urgent. And this case at paragraphs 5 and 6 says exactly that. If I can just read paragraph 5, that's on page 3. It follows that whatever the nature of the claim, there must be some reason why the applicant will not be able to protect or advance their legal rights later, unless they are given specific relief now. Most of the time, the applicant requires no more than temporary protection from harm, while the process of finally determining their rights progresses. Sometimes, though, a final determination of rights is necessary on an urgent basis because those rights will have little or no practical effect if the applicant has to wait weeks or months to vindicate them in the ordinary course. We're not dealing with that situation here, my lady. There is ample opportunity in the weeks or months that follow for the alleged breaches to be vindicated. And then paragraph 6 is the importance line. I won't read the whole paragraph, but the judge there says, there is accordingly no class of proceeding that enjoys inherent preference. Counsel appearing in urgent court would, in my view, do well to put the concept of inherent urgency out of their minds. There are, of course, some types of cases that are more likely to be urgent than the others. The nature of the prejudice an applicant will suffer if they are not afforded an urgent hearing is often linked to the kind of right being pursued. And there the court continues dealing with spoliation matters. And right at the bottom, the last sentence of that page, court says cases involving possible deprivations of life and liberty, threats to health, the loss of one's home or some other basic essential of daily life, such as water or electricity, destruction of property or even crippling commercial loss, are likely to be urgent. But that's not alleged here. It may have been a different story if this applicant was still in jail. That's not the case here. The second judgment which I'd like the court to have regard to, and this will also tailor the way I address my argument to the court, is the unreported matter of Mogalakwena Local Municipality versus Provincial Executive Council Limpopo. This is a judgment of Tokton J in the Pretoria High Court. The relevant part is, pages aren't numbered, but it's 3 pages from the back at numbered paragraphs 63 and 64. Halfway through paragraph 63, the judge refers to Rule 612 and says, Rule 612 confers a general judicial discretion on a court to hear a matter urgently. 612b provides, in every affidavit or petition filed in support of any application under paragraph A of this subrule, the applicant shall set forth explicitly the circumstances which he avers render the matter urgent and the reasons why he claims that he could not be afforded substantial redress at a hearing in due course. It seems to me that when urgency is an issue, the primary investigation should be to determine whether the applicant will be afforded substantial redress at a hearing in due course. If the applicant cannot establish prejudice in this sense, the application cannot be urgent. So that's our argument here, my lady. The applicant has to satisfy this court that she cannot obtain substantial redress in due course, and that's certainly not the case. At 64, it then continued. It continues. Once such prejudice is established, other factors come into consideration. These factors include, but are not limited to, whether the respondents can adequately present their cases in the time available between notice of the application to them and the actual hearing, other prejudice to the respondents and the administration of justice, the strength of the case made by the applicant, and any delay by the applicant in asserting its rights. So we submit that we don't even need to go there, but in the event this court does find that there is a possibility that there can be no substantial redress in due course, the respondents have set out sufficient in their answering affidavit in this matter to show that all of those factors, the prejudice, not being able to, for the administration of justice, etc., and the strength of the case are simply not met in this matter, and the balance favours the respondent. My lady, on this point, before I get into my prepared argument, the case of Magudubana that my learned friend referred to in her head of argument, and there was a bit of a debate between the court there. I haven't been able to have a look at it. As I mentioned, I only got the heads at the start of this matter. But having regard to the portions that my learned friend read out to the court, it seemed to me that the court there may have made some sort of exception, but that's on the basis of the self-created urgency type of arguments, whereas there had been, it seemed, about a month between the applicant becoming aware of the facts there and approaching this court, and that period of time not having been adequately explained. In this matter, the respondents have not taken issue with any sort of self-created urgency or any delay in bringing this. In fact, their argument is the opposite. This application was brought far too quickly. It was served last week, Wednesday, the 21st, and we are here today on Monday at 2 p.m. to handle this matter. We had just over 24 hours to prepare an answering affidavit in this matter. So that case seems, from what I heard, the portion that my learned friend read to the court, to be very distinguishable to the facts in this matter. So we submit that it's long been established in the case all the requirements for urgency, and they have to be satisfied by the applicant here. My lady, if I may then turn to the three issues which have been dealt with in our heads in respect of the respondents' particular positions in this matter. The first is that they were not given adequate time to prepare. The second respondent is the Minister of Police. We state in our answering affidavit that he has not previously been cited in any of this litigation, whether it be the Constitutional Court, the bail, anything like that. So he's not aware of this matter. It was only in reply that the applicant, in fact, stated that he was just cited because he has supervisory control over the third respondent. So we weren't aware at the time of the founding affidavit what his role was in this matter, but he's, of course, entitled to be brought up to date to now consult with his employees and find out what his stance in this matter will be. The third respondent, that's Captain Carlitz, he was out of town on work. It wasn't leave or holiday or anything like that. He was on other work for the Directorate of Priority Crimes, and he could not meet to give detailed instructions in this matter. If I may just pause there for a minute. It's true that he deposed to a founding affidavit in the Constitutional Court dealing with the events that took place in the United States with the alleged torture, abuse, duress, etc. He has denied those allegations completely, and those remain denied. That version will not change in the event this application is pursued in due course.
So should the court then be given a statement by Carlitz, then he will deny the allegations of the applicant in this matter?
As the court pleases, my lady.
It will be disputed.
My lady, the answering affidavit that was attached to the founding affidavit, yes. This is the answering affidavit in the Constitutional Court papers, yes. That denied those allegations outright. He, in fact, if my memory serves, he in fact stated that he was shocked and hurt by accusations having been made about apartheid-era tactics being employed by him. So to the extent that some of those allegations have found their way in this application, they will again be denied. That there was any sort of abuse or maltreatment of the applicants during that interview process.
And that is common cause to both parties, that statement was before the Constitutional Court.
That statement was, yes. In fact, it was attached to the applicant's founding affidavit. Yes. So there's no reason to say on the papers anyway that Captain Collins would change his version now in opposing this application in due course. He has denied that there was any abuse of the applicant's constitutional rights there. Took it personally, as he would have, with his name being cited, personally cited, and he denies that any constitutional rights were breached by him and his colleague, Brigadier Gerber, during that process. So that will still be the position here. It's just he was unable, in the 3 days given to him, it was served Wednesday, on Thursday, Friday, to now come and have a look at this application in detail and deal with those sorts of parts of the application which have now been repeated here. But we have the other aspect, of course, that as my learned friend started her address to the court, it arose from the bail hearing, which was only held on the 15th, I think, of August was when that judgment was handed down. So those are new parts which haven't yet served before this court, and instructions would have to be given by Captain Collins on the events that took place there. So that's the position of the second and third respondents dealt with, while they couldn't oppose this fully in time. The final one is the first applicant, being the Director of Public Prosecutions Free State. It's correct that she filed an affidavit in relation to the extradition proceedings, and she confirmed the opposition and that Captain Collins could represent her in the constitutional court proceedings. That was just a confirmatory affidavit. However, again, the applicant's case now arises from the bail hearings. The applicant has not said that the DPP was present at those bail application hearings. I was there for part of them. She was not present at those hearings. I know now I'm giving evidence from the bar, but I think that would be common cause. So how is she, with personal knowledge, supposed to depose to an affidavit as to what happened in those proceedings unless she could meet with her state prosecutor who ran those proceedings, who was Advocate de Nation, who was on annual leave during the course of last week? She needs to meet with him, take instructions from him, and formulate the defense to this matter. There's certainly nothing surprising or state delaying or trying to pull a fast one over the applicant here. That's just the facts of this matter. And that is the risk that an applicant takes when they bring a matter not only urgently, but extremely urgently. And particularly so when it's against the state, my lady. The matter I've referred to in my heads of argument, a well-known judgment in Johannesburg, so I know my learned friend will know it, in raised several matters on the urgent court roll 2013-1 SA 549 GSJ. I refer to it in my heads. Footnote 25 on page 11, and it's at paragraph 28. So in the judgment at paragraphs 16 and 17, the learned Justice Veerpinner refers particularly to urgent matters which are brought against the state. He says at 16, there are also matters brought against the state. Experience has taught that such respondents need time to look into the allegations made in order to be able to file affidavits if they so wish. When these affidavits are filed, the matters can be seen in a proper perspective. Attempts to disallow them to file affidavits are usually based on the judgment in Arce versus Minister of Home Affairs and others, I'll leave out the citation, where it was said in paragraph 10 that a detained person should not be deprived of his or her right to freedom for 1 second longer than necessary. Milan J.A., however, added the words that the detention should not be longer than necessary by an official who cannot justify his detention. This statement must be seen in its proper context. It does not say that all persons who are incarcerated are entitled to be released post-haste. It deals with unlawful incarceration, and that determination can only be made upon a proper consideration of all the facts as the governing legislation specifically provides for incarceration. By allowing the respondents to place facts before the court to attempt to justify the actions of their employees, the matter can be properly considered. Success or otherwise of the respondent's opposition to this matter can only then be determined. At paragraph 17, he continues, an abuse of the process has developed, in all likelihood in the hope that the respondents will not be able to file opposing affidavits in time, in order to steal a march on such respondents. This practice must be addressed in order to stop matters being unnecessarily enrolled and clogging the urgent court roll. In these matters, sufficient time should be granted to the respondents to file affidavits, and they can really do so when the papers are served less than a week before a matter is to be heard. That week includes a weekend when the state machinery normally comes to a standstill. My lady, this case is exactly on point here. These state respondents were afforded 24 hours, or just more than 24 hours, to file an opposing affidavit. It's simply not suitable for them, it's not suitable for the court, and being a weighty matter as this matter is, with severe repercussions for the state actors seeking their conduct has been declared unconstitutional, etc., submit that more time ought to have been granted, and in fact this matter ought to have been brought in the ordinary course or technically at the commencement of the trial.
So if we for a moment accept that this is a public interest case, the relief sought is, we must keep that connection when we adjudicate the matter today, is that the prosecution of the applicant on charges of fraud and corruption is declared unconstitutional and invalid.
Yes, ma'am.
That's the relief sought. It's not a release or there is no issue of habeas corpus that she's illegally in custody. It is that the charges of fraud and corruption is declared unconstitutional and invalid.
Yes, my lady. Paragraph 4 does also seek an order that the Director of Public Prosecutions in the Free State must withdraw the unconstitutional charges against the applicant.
I'm going there. The third clause, or the third part of the relief, is that the conduct of the state in the extradition of the applicant renders the extradition unlawful. And then 4, directing the Director of Public Prosecutions in the Free State to withdraw the unconstitutional charges against the applicant there. So this is the relief sought. So we must keep context. Context is imperative in the decision of the urgency here. And what do you say? Should I find that this is public interest? It's important. But I do not have, in terms of the audi alteram partem rule, I do not have any evidence from the opposing side. I only have the evidence of the applicant. Would I do the responsible thing to ponder the case on this basis?
No, my lady. What my lady would do, if that's the view that there is some urgency in this matter, because that is the first question, would then be to either accept the applicant's papers as they are, which I submit the court with respect cannot do, at least given the fact the answering affidavit filed in the Constitutional Court dealing with the extradition aspects. That's already the state's version that is placed before this court in relation to that part of the relief sought. But what the court must then do is, I suppose, put the state on terms to file an answering affidavit on the merits.
So that I can do an informed and responsible adjudication of the matter.
Yes, my lady, but my submission goes one step further on that, and that is that type of that proceeding and that directive to pursue the matter further should take place within the context of the criminal trial. And those dates would best be agreed by the parties with the presiding judge at the pre-trial hearing that will take place on the 11th of September. That's when all the accused will be present, I believe, and that judge knows about the 15th of April date when the criminal trial commences, and can make arrangements between the parties to make sure that the applicant does have her rights of access to court seen to and exercised, but also not prejudice the criminal trial and whatever is happening in that proceeding.
Can the parties not meet each other halfway in this application and then decide or agree or settle on the issue of the fact that you didn't have the opportunity to file your information, and that the court can make an order in that regard?
And my lady, if my learned friend wants to make some proposals, I can take instructions on that regard. I would have thought once the answering affidavit was served, that might have been the approach that was adopted, but we have not heard anything.
You haven't received any?
We received a replying affidavit, and then we're here today arguing. So it seems that they persist that this matter is urgent and they want to determine today.
The merits? The
merits, yes.
Thank you.
And my lady, I've dealt with the respondents not having an opportunity to have properly prepared in this matter and why that was the case. The second criteria or factor that the court should take into consideration based on this Mogalakwena judgment is the prejudice, and this is the respondent's prejudice. My learned friend has said that in the first instance that the respondents are seeking discovery. That's not true. The respondents filed a Rule 3512 notice, which is provided for in the rules, and which states that if any document is referred to in an affidavit, it applies in applications that should be attached. The Auditor General report, Public Protector report, etc., were not attached. Yet the applicant wants to say that there are common cause facts in there. That's simply not. They're not in a position to make that any submissions in relation to those reports without them being before this court. And it may come down to a matter of interpretation. Yes, the respondents are not going to say that there was no Auditor General report in this matter, but as to the meaning sought to be drawn from that, which, if I understand the applicant's case, is that she was not identified there as a wrongdoer, so the state's case against her is malicious in some way. Well, we need to see what the context of that report is. it seems from what is alleged in the founding affidavit that it dealt with audit reports and spreadsheets and the like. Well, that might be the case, and it's limited of scope, which wouldn't even have involved the applicant in this matter, and it may not even relate to her charges. The court needs to be apprised of what that document entails, and the respondent needs to be able to address those situations, those submissions. That document needs to be before the court. It's an entitlement that the respondent has and the court has. It was not discovery, it was merely asking for copies of documents that were referred to in the papers. And I double-checked the answer and my heads of arguments, and nowhere there did we say that we do not have these documents. We've never had sight of them. We merely exercised our right in terms of Rule 3512 to request those documents.
So do I understand you correctly that it is your submission that the court does not have all the facts?
Yes, my lady, and that's prejudicial to the respondent, of course, and that's the area I'm dealing with, but of course to the court as well. I don't know how the court can make a finding that the state's case is against the applicant is weak or non-existent based on a report which supposedly does not finger her, when that's simply not before the court. That report is not before the court. So that's, yes, it's prejudice to the court as well. So that's the first aspect of prejudice. The other one is the extremely truncated time periods. In order to brief counsel, meet with the persons, that it's prejudicial to the respondent there, and it really overlaps with the previous subject I dealt with. Then there's another aspect which I think is important to raise, although there may be a bit of a departure between my learned friend and I here. That's the non-citation of the Minister of Justice. So, my lady read out paragraph 3 of the relief sought, which was that the conduct of the state in the extradition of Nomalanga Moroadi Cholota renders the extradition unlawful. So that unlawfulness declaration would emanate from the extradition which took place under the Extradition Act. The Minister of Justice is responsible for that act. So, yes, it treads a line because Rule 10A only says that when that legislation is sought to be declared unconstitutional, that the minister would be cited. But here we have a minister who has filed papers to request their counterparts in the United States to proceed with an extradition, which the applicant wants declared unlawful. That minister, I submit, has a right to be before this court and place their version before this court and defend the conduct in that regard. So that's a material non-joinder point that hasn't been raised as a point in limine here, but that is something to consider for the prejudice here. And also, going forward, we would submit, if the matter then proceeds in the ordinary course, as things currently stand, that would be a point that these three respondents would take, that there's a material non-joinder. The final aspect I said to the court, we're not dealing with any sort of self-created urgency or delay on the part of the applicant here. So, in relation to these Mokhalakwena criteria, the final one we're dealing with is the strength of the applicant's case. The state's version is that these types of applications are inherently weak. They have been previously unsuccessful in relation to this particular prosecution. 4 of the applicant's co-accused previously brought similar applications declaring certain evidence unconstitutional, declaring their prosecutions unconstitutional, etc. And those are all referred to in the judgment of Mokesi versus the state, which I handed up to the court. They were found the applications were dismissed, and the court found that they should be dealt with at the criminal trial themselves. So there's not only precedent in this particular matter that these applications should be pursued at the criminal trial, but there's the Sheikh matter, Filia's matter. I've referred to them in my heads of argument, my lady, where our courts have previously said that these types of matters, which are interlocutory, should be dealt with at the criminal trial. Otherwise, they end up in delaying the matters. So there's that, and it should be taken in the form of a special plea. That's the judgment my learned friend relies on, S versus Mahala. That's the course of conduct that this applicant should take. Then there's also the fact, and this goes to the strength of the applicant's case, that she has contradicted herself on oath in the bail application proceedings. I'll just find my place. The applicant said that she was determined to prove her innocence and to attend her trial. If I can get the right wording, because I don't want to misquote her. Our record was at paragraph 20 of that founding affidavit. I've referred to it in paragraph 35 of my heads of argument at page 14. And right at the bottom, the applicant says, I intend to stand my trial and attend all required dates for the hearings, as I am determined to prove my innocence and prove the unconstitutionality of my arrest and the charges against me. Less than a week after the bail application is ruled in her favour, she brings this application seeking that the charges against her are dropped before even pleading in the matter. That's simply just incongruent conduct and shows that this applicant's version between one proceeding and another proceeding have altered. Then, my lady, finally, there have been the United States District Court of Maryland, the magistrates in the court below, and of course the mere fact that the DPP is pursuing this prosecution in this court, which shows that there is a case against this applicant and she ought to face the charges she has been charged with, serious offences of fraud and corruption. I know in reply the applicant has disputed that the magistrate court made any finding or statement in that regard. We won't necessarily say finding, but if I can, now that I've seen the judgment, at page 9 of this judgment, that's Exhibit A, at paragraph 18, line 18, the court said, the next factor under G is the strength of the state's case against the accused and the incentive that she may have in consequence to have an attempt to evade trial. There is sufficient evidence to charge her. As already said, there is an indictment, and if the DPP decided to charge her, they must be satisfied that there is sufficient evidence to charge her in the High Court. So the magistrate below, with respect, did state there is sufficient evidence to charge her. Mere fact that she was extradited upon court order from the United States means that that court found similarly, and thus she has a case to answer on the criminal charges. So for this court to find that the charges of fraud and corruption are unconstitutional and invalid, we submit would be incongruent, would be unacceptable on the facts that are before this court at this time, and in due course, even opposing when this matter is set down for the merits, if the matter is set down for the merits in due course in the ordinary role, or when there's a special plea that's raised, there is a case against this applicant to answer in the criminal trial. She ought to stand those charges, stand her charges on the trial, lead any evidence she wants to at that point, take any special pleas she may want to in relation to her extradition, and she can get her substantial redress at that point in time. So we submit that, yes, those three factors as well this court should take into consideration, and those all in favour of the respondent in this matter.
I wonder about the issue of the fact that the extradition is claimed to have been unlawful and unconstitutional, and that the charges as well are unconstitutional and illegal. But there was a full-blown bail application on a Schedule 5, am I correct?
Yes, my lady.
So, to have a bail application, the applicant at that stage should have been lawfully in custody.
Yes, my lady.
Was the issue of lawful custody ever raised in the bail application?
I think there's a bit of a dispute between the parties there.
About that.
On these, I know my learned friend
I don't want you to testify from the bar if you don't have the... Good. Thank you. Anything else?
As the court pleases, may I just take an instruction?
Thank you.
As the court pleases, thank you.
Thank you. Thank you. Madam, in reply?
Thank you, my lady. My lady put a very, very interesting proposition to my learned colleague, in which my lady asked, since there are public interest considerations at play, would it not be prudent to have the respondents file a meaningful reply in order for the court to meaningfully consider it? If memory serves me correct, my learned colleague then responded that we would not be amenable to that because we appear to really be wanting a resolution on an urgent basis. Milady, I've taken instruction from my attorney. We are more than willing to meet the respondents halfway. The reason why that was doubled down on in the replying affidavit is because the respondents filed an interim answering affidavit. Whenever someone uses the word interim, there is an assumption there that there will be a final something, but nothing final was ever filed, nor was there any indication of affidavit in due course would be filed. However, if we can agree on a date, perhaps a week from now, a week and a half from now, in which they can file a meaningful reply to our submissions, in particular the issues of public interest and the constitutional rights that have been infringed, we would greatly appreciate that. In my oral submissions prior to my learned colleague's response, we were quite rather emphatic that the absence of a meaningful reply by the state really cast things in not such a definitive light for the applicant.
Well, it's almost impossible to adjudicate this matter
Indeed.
in the manner that you want me to adjudicate the matter if the audi alteram partem rule is not complied with.
Indeed.
I do not have all the evidence, and it would be reckless of me to today go into the merits and decide the merits if I don't have all the facts.
That is accepted by us, Milady. It was just to explain that the reason why that was said in the replying affidavit was it was open-ended. However, if we can have an undertaking from the respondents that they could file an affidavit within the next week, since everyone is back from leave, we could accept that if it's within the next week and a half. However, I think the only thing was just our trepidation with regard to the 11th of September. However, if that is possible on their part, then we are more than willing to engage with them as to where we can meet halfway, because we are in agreement that those are allegations that do require meaningful response on the part of the state. Additionally, Milady, if this is indeed the case, we have discussed with my attorney, and we can then go and source the documents from the Public Protector report, from the Auditor General's report, from the SIU, since we were able to find them on the internet, and we can make those available to the state so that they can also consider those and respond meaningfully to our case, and that it can be properly before this court. There can be no assertions that there's not enough time, and also if we can, in the event that they do agree to do that, if we are able to have a right of reply to whatever answering affidavit they will have filed. But the important thing for us, Milady, and I cannot stress this enough, is the proper vindication of these rights. And so if in order to do that, they require more time as they envisaged in their answering papers, then we are more than willing to meet them halfway on that.
I can then not allow the matter onto the roll in terms of Rule 612.
We are alive to that. Milady.
So that is the calamity that I am faced with, is the fact that Rule 612 then falls away.
We are alive to that. Milady.
And I cannot allow the case on the roll on the premises of urgency. So that would mean that I allow the matter on the roll, but on what basis?
That is what we would have to discuss with the respondents, Milady.
Yes.
Yes.
By agreement, what basis? And then, of course, the inevitable consequence is the issue of costs. That you will be with the costs.
Milady,
so you will have to make the choice.
Yes.
If you agree with me that the matter shouldn't have been on the roll today because I didn't have enough evidence before me to adjudicate the matter, I could not allow it on the basis of urgency, then you will be mulcted with costs.
Could I make an alternative point to what we are suggesting, Milady? We're not suggesting that we agree that the matter ought not to have been before Milady. We explained why it was that we opted to bring this matter on the urgent basis that we did, and we also provided reasons as to that. However, we wish to call into argument here the Batterstar judgment, that where a civil, or rather where a citizen is vindicating their constitutional rights against the state, then to mulct them with costs when vindicating those constitutional rights in good faith would not be the court stated against that where litigants are pursuing their constitutional rights, which our founding papers are peppered with, that is the only reason that we did bring this case here, to vindicate our constitutional right, then in that instance, then costs against a litigant in that instance would not be in the interest of justice or fair. That's our only submission in that regard. However, the reason why we agree with the suggestion that Milady has put is, again, because we did not want to be contentious with the respondents and be insisting when will you be filing an answering affidavit and things like that. However, where there is an opportunity for them to file such, and where there is an undertaking that they will be filing a meaningful reply, then we are open to that. And so it would be by agreement and not so much by a contention or an agreement that the matter was not supposed to be before Milady to begin with.
So it's a bit ambiguous. We will have to decide on urgency.
Indeed, Milady.
And you still maintain that the matter is urgent?
We still maintain that there was a reason that we be before this court today.
No, there might be a reason, but is it an urgent reason?
We still maintain it's urgent, Milady.
Urgent. Then the consequence will be that the court will have to rule on urgency and whether I can allow the matter onto the roll or not. That is the consequence. And then on the issue of civil rights, constitutional rights, that a person may not be mulcted with costs, there is now newer judgments that indicate that that is not an absolute right.
And we were not bringing it because of that.
The applicant must go around with this right, this Section 34 right, very maturely and very responsibly.
Indeed.
And can't just run to the court on an urgent basis and they're not expected to be marked with costs.
Indeed.
So I will adjourn for a few minutes for you just to consult with each other, but you must remember that you are now burdened with the issue of urgency. Thank you. You wanted to say something?
Milady, if I may just, my submission when Milady asked me that question about the court would then have to give us directives to agree time limits and etc. to file, that was premised on the assumption that this court rules that the matter is urgent. That was the basis upon which it was made. I'm not conceding urgency or anything.
So
like
you
that.
don't concede that there will be any arrangement?
No,
so I will have to rule on urgency or not?
Yes.
So that is the situation. Any settlement negotiations will apparently not be successful, ma'am. Do you also understand it like that?
I understand, my lady, and we are obviously unsurprised at the state's course of action. We had already indicated how the state has dealt with us in the past, and so there's no surprises on our side as to that course of action. But we were merely responding to the fairness of Milady in that suggestion.
Good. So then I am going to make my ruling on urgency. It is extempore and it's just going to be the order. Having heard arguments for both the applicant and the respondent in the instance, and having had regard to the papers filed off record, this is the order of court. The application in terms of Rule 612A to enrol the matter as one of urgency and to dispose with the forms and service provided for in the Uniform Rules of Court is dismissed with costs. Reasons for this order will follow in due course. Thank you. The court is adjourned.
As the court pleases.